Hello and welcome to a lecture on abetment. In this lecture, we shall focus on the definition, meaning and punishment of the offence of abetment. Section 120A and 120B were added by the Indian Penal Code by the Criminal Law Amendment Act 1913 to fill the gap in Section 107 dealing with abetment. Before this amendment, conspiracy under IPC could be punished only when an act or omission took place in order to the doing of conspired act. Except in respect of offences under Section 120A, conspiracy was not a substantive offence. Past experience showed that dangerous conspiracies were entered into India whereby an anarchical situation was created and then existing law was inadequate to deal with them. The amendment of 1913 was therefore designed to assimilate Indian law to English law with additional safeguards that in the case of conspiracy other than a criminal conspiracy, some overt act is necessary to bring the conspiracy within the purview of the criminal law. These new sections 120A and 120B have made the law very clear and more readily available in all possible circumstances. Now, the position is that conspiracy is not only a form of abetment but also a substantive offence. Let us try to understand the meaning and definition of abetment. In commission of crime, sometimes more than one person is involved, sometimes one person only suggests the actual offender to do the act and the main accused commits the crime. The first person will be called as abettor and act will be called as abetment. When several persons take part in the commission of offence, the liability of each person is determined about the degree of culpability in the case. For example, A encourages or instigates or provokes or engages B to commit murder of C is an instance of abetment. Thus, a person may commit an offence in conjunction with other persons. In such a case, the degree of liability for commission of the crime varies from one person to another. To abet means to help in doing something. If an offence is committed on the advice or instigation of another, it is called abetment. The person who abets is called abettor. Abetment of an offence is punishable both in English law as well as in Indian law. Section 107 IPC defines abetment and Section 108 explains who is an abettor. Let us move towards understanding the types of offences and offenders. According to the English law, the offences and the offenders are classified into these degrees as per the involvement of each offender. Number 1, principal in the first degree. Number 2, principal in the second degree. Number 3, accessory before the fact, and number 4, accessory after the fact. Let us understand these types in detail. Number 1, principal in the first degree. Principal in the first degree means a person who actually commits the act and others provide him all the assistance and help in commission of the offence. If the crime is committed through an innocent agent, then the person who instigates the commission of offence is the principal offender. For example, a doctor administers poison to a patient through a nurse, saying that it is a medicine. Here, the doctor is the principal in the first degree. The second one is principal in the second degree. Principal of second degree is one who provides all the assistance or help to the principal of first degree to do the crime. The principal in second degree are those who aid and assist in commission of the offence. The principal in second degree does not take part in commission of actual offence. Stephen explains that a principal in second degree is one who aids or abets the actual commission of crime and is present either where he has committed the offence or elsewhere. While studying the law under IPC, we find that there is no distinction on the basis of the principle of first and second degree. But the framers of Penal Code have kept this distinction in mind when they drafted Section 109 and Section 114 of IPC. For example, if a person aids robbery by giving signal from a distance, he is principal in the second degree. The third one, accessory before the fact. Accessory is the person who advises the principal to commit crime. A person who helps the offender before the commission of crime is known as accessory before the fact. He is always absent from the place of crime, but he helps, procures, and counsels the accused to the crime. To be the accessory before the fact, it is necessary that there should be a desire on this part that act should be committed. For example, A directs B to poison C, but B kills C by shooting. A is accessory before the fact to C's murder. Suppose B rapes C's wife, A is not accessory before the fact. And the last one is accessory after the fact. He is a person who assists the criminal with a view to protect him after the commission of offense. In other words, a person who receives or protects or maintains a known criminal or helps the criminal to escape after the crime is an accessory after the fact. Dear friends, I hope you have clearly understood the types of offences and the offenders. Now let us move towards the forms of abetment. The criminal act can be committed by an individual of his own will, or he can do the act on the suggestions or advice of other person with a common intention. The act when committed on the advice of the other person will be called as abetment under Indian law. The abetment under the Indian law takes three forms, and the law of abetment is contained in section 107 IPC. According to section 107, abetment may take place by these three methods. Number 1, abetment by instigation. Number 2, abetment by intentional aiding. And number 3, abetment by conspiracy. Let us go through them one by one. Number 1, abetment by instigation. The literal meaning of instigation is to urge forward, to incite, or encourage to do an act. Therefore, instigation is the act of inciting others to do a wrongful act. In order to establish the instigation, some act is necessary which has the effect of encouragement on the principal offender. Instigation means inciting a person to do a wrongful act. An inciter is one who counsels, commands, or advises the commission of a crime. A person is said to instigate another when he actively suggests or stimulates him to do an act. Mere gestures directing a person to do a wrongful act also amounts to abetment. An example of this kind is in R versus Mohit Pandey. In this case, silent approval producing an effect of incitement was held to be an abetment by instigation. In this case, a woman prepared herself to perform sati. Certain people followed her to the cremation ground and were reciting Ram Ram, standing by her funeral pyre. They were held guilty of abetment by instigation. A offers bribe to B, a public servant, as a reward for showing some favor in the exercise of B's official functions. B refused to accept the bribe. A is guilty of abetment by instigation and is punishable under section 161 IPC. Instigation can be made by various acts. This can be made even by letters. For example, if A writes a letter to B to commit an offense, the instigation is complete as soon as the contents of the letter are known to the addressee. But if the letter does not reach to the addressee, offense is not complete. The second one is abetment by aiding. It consists of, number 1, either in the doing of an act directly assisting the commission of the crime, or number 2, in the doing of an act though not directly assisting in its commission affords facilitates for its commission, or number 3, in an illegal omission resulting in the same consequence. In order to constitute abetment, the abettor must show to have intentionally aided the commission of the crime. Intentional aiding and therefore active complicity is the gist of the offence of abetment. Mere presence at the place of commission of crime cannot amount to intentional aid unless it was intended to have that effect. Intention to aid the commission of the crime is the gist of the offence of abetment by aid. The third one is abetment by conspiracy. Conspiracy means an agreement by two or more persons to do an illegal act or a legal act by an illegal means. To constitute abetment by conspiracy, two or more persons must conspire and one of the persons must be the person abetting. The act must be an act committed in pursuance of the conspiracy and a probable consequence of it. Let us further move towards the definition of abettor. Section 108 IPC defines abettor. A person abets an offence who abets either the commission of an offence or the commission of an act which would be an offence, if committed by a person capable by law of committing an offence with same intention and knowledge of that of an abettor. The abetment of an illegal omission of an act may amount to an offence, although the abettor may not himself bound to do that act. To constitute the offence of abetment, it is not necessary that the act abetted should be committed or that the effect requisite to constitute an offence should be caused. A instigates B to murder C. B refuses to do so. A is guilty of abetting B to commit murder. A instigates B to murder D. B, in pursuance of the instigation, stabs D. D recovers from the wound. A is guilty of instigating B to commit murder. It is not necessary that the person abetted should be capable by law of committing an offence or that he should have the same guilty intention or knowledge as that of the abettor or any guilty intention or knowledge. The abetment of an offence being an offence, the abetment of such an abetment is also an offence. A instigates B to instigate C to murder Z. B accordingly instigates C to murder Z, and C commits that offence in consequence of B's instigation. B is liable to be punished for his offence with the punishment for murder, and as A instigates B to commit the offence, A is also liable to the same punishment. It is not necessary to the commission of the offence of abetment by conspiracy that the abettor should concert the offence with the person who commits it. It is sufficient if he engages in the conspiracy in pursuance of which the offence is committed. Section 108A, Abetment in India of offences outside India. A person abets an offence within the meaning of this code, who in India abets the commission of any without and beyond India which would constitute an offence if committed in India. A in India instigates B, a foreigner in Goa, to commit a murder in Goa. A is guilty of abetting murder. Section 109. Punishment of abetment if the act abetted is committed in consequence and where no express provision is made for its punishment. Whoever abets any offence shall, if the act is committed in consequence of the abetment, and no express provision is made under this code for the punishment of such abetment, be punished with the punishment provided for the offence. Section 111. Liability of abettor when one act abetted and different act done. When an act is abetted and different act is done, the abettor is liable for the act done in the same manner and to the same extent as if he had directly abetted it, provided that the act done was a probable consequence of the abetment and was committed under the influence of the instigation. For example, A instigates B to burn Z's house. B sets fires to the house and at the same time commits theft of property there. A will not be guilty of abetting theft, for the theft was a distinct act and not a probable consequence of burning. Section 112. Abettor when liable to cumulative punishment for act abetted and for act done. If the act for which the abettor is liable under the preceding section is committed in addition to the act abetted and constitutes a distinct offence, the abettor is liable to punishment or each of the offences. Section 113. Liability of abettor for an effect caused by the act abetted different from that intended by the abettor. When an act is abetted with the intention on the part of the abettor of causing a particular effect, and an act for which the abettor is liable in consequence of the abetment causes a different effect from that intended by the abettor, the abettor is liable for the effect caused in the same manner and to the same extent as if the act with intention of causing that effect, provided that he knew the act abetted was likely to cause that effect. Section 114. Abettor present when act is committed. Whenever any person who is absent would be liable to be punished as an abettor is present when the act or offence for which he would be punishable in consequence of the abetment is committed, he shall be deemed to have committed such act or offence. Section 115. Abetment of offence punishable with death or imprisonment for life if offence not committed. Whoever abets the commission of an offence punishable with death or imprisonment for life shall, if that offence be not committed in consequence of that abetment, and no express provision is made by this code for the punishment of such abetment, be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Section 117. Abetting commission of offence by the public or by more than 10 persons. Whoever abets the commission of an offence by the public or by any number or class of persons exceeding 10 shall be punished with imprisonment of either description for a term which may extend to 3 or with fine or with both. Section 118. Concealing design to commit offence punishable with death or imprisonment of life. Whoever voluntarily conceals by any act or illegal omission the existence of a design to commit such offence or makes any representation which he knows to be false respecting such design, if offence be committed, shall be punished with imprisonment of either description which may extend to 7 years, if offence be not committed, with imprisonment of either description which may extend to 3 years, and in either case shall be liable to fine. Section 120. Concealing design to commit offence punishable with imprisonment. Whoever intending to facilitate or knowing it to be likely that he will thereby facilitate the commission of an offence punishable with imprisonment, if offence be committed, shall be punished with imprisonment of description provided for the offence, for a term which may extend to 1/4, and if offence be not committed, to 1/8 of the longest term of such imprisonment, or with such fine as it provided for the offence, or with both. With this, we come to the end of the lecture. Hope you have enjoyed it. Thank you for watching.